Let's bring in MSNBC legal contributor Katie Phang, MSNBC legal analyst Charles Coleman, and state attorney for Palm Beach County, Dave Aronberg. Good to have you all. I'll go in order. Katie Phang, your takeaways from, I know everyone's just reading this lengthy documents. What's your first takeaway?
Yeah, Mika, so having had the chance to review this order, a lot of us predicted that there was no actual conflict of interest because based on the law, the evidence that was submitted during the course of this hearing, Mika, made it clear that that didn't exist. The question of what legal standard Judge McAfee was going to apply was the biggest question that just got answered. He kind of did a hybrid, right? He said no actual conflict. However, an appearance of impropriety when it comes to specifically the role of a prosecutor is found here. Now, it's a little bit of a Solomon's choice, right? Do you keep Fani Wade or do you keep Nathan Wade? I mean, I think it's a no-brainer, right? You get rid of Nathan Wade, but to the point that you've made and that everybody has just made, including Jonathan Lemire, the delay factor. Remember Nathan Wade's role in this. He started before the special grand jury was even put together. He kind of spearheaded this investigation. So he took this investigation, he fed it into the special purpose grand jury, got those results, and then he also participated in the grand jury. And so you have to think about the institutional and historical knowledge that Nathan Wade has. All of that being said, if the solution here is to move forward with DA Fani Willis and the rest of her team, including the other skilled and incredibly competent special prosecutors in Anna Cross and in John Floyd, who we know is the king of RICO or the, kind of the professor of RICO in Georgia. Again, like I say, Mika, it's a no-brainer. That's what you do.
Yeah. For sure. Dave Aronberg, I'm curious your first gut reaction to this order.
Mika, I think this is a victory for Fani Willis. She gets to stay on the case, and the case will continue, even though it's been delayed. I thought the judge would try to split hairs here, remove Nathan Wade and keep Fani Willis. But how do you do that? Because if you don't believe Nathan Wade, then how do you believe Fani Willis? Because she adopted Wade's affidavit. And that's the tension here. But the judge decided to try to walk that tightrope. Because the standard is indeed whether there is an actual conflict, not a perception of one. And there was no actual conflict here, but there is an appearance of impropriety. So one of them has to go, and it will be Nathan Wade. And quite frankly, it should have happened already. If it had, we wouldn't have had all this.
So, Charles, let's get your reaction as well. I mean, at minimum, poor judgment shown here by the district attorney. It does seem that the choice ahead of her is pretty clear. Can we just get, what is your first immediate thoughts as to what we're reading right now?
Well, like Katie, and I do want to give Katie all her flowers as she's due, she was the first of our colleagues to point out the actual standard of Georgia law when it came to the removal of a prosecutor. And I have been thinking about that since she pointed this out way at the beginning of all these hearings. There was really only one way that the judge had to go if he was going to follow the law, and that was if there is not evidence of an actual conflict, which we did not see presented, Fani Willis had to remain as the DA. Now, he did carve out some things with respect to the removal of Nathan Wade, and I did anticipate that there would be a rebuke of Fani Willis's behavior, and I see on page 9, the judge has written, "This finding is by no means an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing." That is very strong language, and it's something that I expected you would hear from the judge in this case. All of that being said, I think this conversation, and Lisa alluded to it, about the notion of polluting the jury pool is really interesting when you start to think about, now you're talking about, with all of these cases, both civil and criminal, a jury pool of the entire electorate. And it's contaminated and cross-contaminated wherever you look because of everything that has happened, and even a decision like this. And so it will be interesting, not only in the legal realm, but also in the political realm, to see how all of this shapes out, given the fact that at this point, you would have to be living under a rock not to have been exposed to some level of information around everything that's been going on.
Yeah, Lisa, this is what we talked about, my gosh, 3 hours ago. It was a long time ago.
Yeah, it's been a long week.
But that's what we talked about. There are other ways for Fani Willis to face the music because of this terrible lapse in judgment, whether it's ethics charges, whether it's the voters who decide not to vote her in. But again, the question is, how does it impact the defendants? It looks like the judge pretty much got to what we were saying 3 hours ago, which was remove Wade. She can continue as prosecutor. And then she faces whatever judgment she faces from the voters or from ethics panels on her own.
Yeah. And Joe, let me just say that there's a lot for people to chew on if they are opponents of Fani Willis here. In particular, the discussion both of her testimony and of that speech she gave to the Atlanta church is brutal. He says essentially that she didn't cross the line into forensic misconduct when she gave that speech, but it's still legally improper. That phrase, legally improper, is one I'm sure that we will hear again and again from folks on the defense side, as well as the conclusion on page 16, that an odor of mendacity remains. One of the other things I think is really interesting here that went on is how Judge McAfee, in addition to deciding what the appropriate legal standard here is, also took us through his thinking about the evidence. He tells us that Terrence Bradley, and this should be no surprise to anybody who watched the hearing, essentially was not a credible witness, that he had too brittle a foundation for anybody to really rest the case on him. He also talks about the fact that Fani Willis's former friend, Robin Yeardy, an employee of the district attorney's office who claimed that the relationship began sometime in 2019 or 2020, that her testimony similarly lacked context and detail that allowed him to really put very much stake in what she had to say. But he did consider, he says, the proffered cell phone testimony. That's essentially this affidavit from an expert who was trying to interpret the cell phone data that Trump tried to put in at the last minute. He also says that he considered what he characterizes as an unorthodox decision by Fani Willis to talk extensively to Michael Isikoff and his co-author of the book, Find Me the Votes. That was something that the defense made a lot out of during these evidentiary hearings. But at the end of the day, he says it was the defendant's burden to establish a conflict of interest here. And even though an actual conflict of interest need not be one, according to Judge McAfee, that prejudices the defendants, and there was some question about whether that was also a part of the standard, he says they just fell short of establishing conclusively in his mind that there was an actual conflict of interest that justified her disqualification. Nonetheless, he was so troubled by the other stuff that went on, including this odor of mendacity, that in the end, he gives this creative choice to Fani Willis. And I don't think we'll hear the end of this. I think you'll see people on the Trump side and defense side try to write letters now, for example, to the state bar, asking them to further investigate Fani Willis, Nathan Wade, and Terrence Bradley for the testimony that they gave in this proceeding, and asking them to take some disciplinary action against one or all of them with respect to what they said to the judge.